All right, let's continue getting more analysis on this case with Alton Hart, who is a legal analyst. Alton, thank you so much for being with us today, as always, as of course we rewind 10 years back to the day that Senzo Meyiwa was actually shot and killed at his girlfriend's house. The legal blunders, wrongful arrests, private prosecution, the change of judges, lost or inactive documents. Quite a lot has transpired. Let's start from day one of how justice has actually eluded the Meyiwa family as a result of how this investigation was initially handled.
Now, if one looks at from the beginning, and I always was one of the people that said that it started off with the crime scene, where the crime scene was left unattended. Then you know already you've got a problem, because certain things could have been removed, certain things could have been added, and then the crime scene is no longer as it was when the act was committed. And for me, already the blunder started there. Then we go into where you get a senior in the police of steps coming to a crime scene, then sending a forensic investigator to leave an active crime scene to go and attend to another crime scene. That started now showing to me that the handling of the crime scene is now being questioned. Then you have the issue where you have now two dockets arising from the same set of facts. Then it tells you that the police is not even sure of what they are doing. And for me, that already created another problem. And so the problems unfolded. Then also the types of witnesses that started popping up as the trial has progressed. It is just amazing, because you say to me in 2020 you had evidence of some photos on certain individuals' phones, yet they are not charged, only charging a selected few people. Why are you doing that? So it's a lot of questions around the procedural and the investigative work that is just, for me, the Meyiwa family has been hard done by how the work is done, and not to say per se as to what is happening in court. The more of the damage was done before the matter even got to court.
Look, Alton, let's talk about the call by the defense now actually asking to admit the statement from Meyiwa's brother, Sfiso, who has, of course, maintained for the longest time that he was on a phone call with one of the people that were in the house who told him another version of events.
For me, if the state doesn't allow that evidence to be considered by court, then it means that there's never sort of a fairness in the process. Because here you've got somebody that's actually rebutting what one of the crucial witnesses for the state on the stand said, to say, listen here, this is what transpired. And now suddenly there's a different version, which means there is two contrasting versions that should be investigated. Why is the state opposed to introducing this evidence? Because that brother will come and testify, and he's got a direct interest to say that, I know my brother got killed, but the 5 people currently in the dock is not the ones that are responsible, because this person, who is a state witness, told me this, and this is not hearsay, it's direct evidence, because that person told him, and he's coming to tell the court. And for me, I think the defense should call Senzo Meyiwa to come and say what was happening in that conversation that he had with this guy, Tumelo Matlala, on that night of Senzo's killing.
You know, it's very interesting, Alton, because according to Senzo Meyiwa, this information he did actually share with the investigators at the time of the investigation. But looking at how long it's actually taken now to actually form part of the arguments, just like those dockets that we do not know still as to why they were actually remained.
For me, it again speaks to shoddy investigative work, and then for me, it shows that the police created a narrative, and a narrative that they believe, and even looking at how the confessions was handled, because they said accused 1 and 2 made confessions. But if you look at a balance of probabilities on that confessions, I could not see even how Judge Harata, even with his years of experience, allowed that confessions to stand. Because you'll always have this one accused against 10 police officers testifying that he was tortured, and they allowed that confessions, because the state's case was built against these 5 accused on straw. There was never a case against them. They failed the Meyiwa family, they failed in their investigation, and I think they are trying to now sort of save the South African Police Service and the investigating team some blushes for the mishaps that happened in how they handled this case. of Senzo Meyiwa from the get-go. And I think now that's why they also sort of have, when Sipiso told them that, listen here, Tumelo Madlala told me this, they sort of have ignored it because now they had a narrative that they can sort of have, bring evidence to actually fit in with that narrative.
Alton, does the Meyiwa family at this stage and so late in the trial have any legal options to stop the current trial and, of course, observe or explore the other narratives as well as versions that we've actually heard about during the entire trial? And also remembering that at some point the state had failed to actually prosecute, leading the family to seek the private prosecution route. And interesting also that in an exclusive now interview, I'm sure you saw it, with Meyiwa's former boss at the time, Dr. Irvin Khoza, he says if he was called, he would actually go and testify during the trial. Now, one wonders, how would his testimony assist the trial, especially at such a late stage? Do you foresee any resolution anytime soon on this matter?
Now, for me now, where we at with this trial, because remember the National Prosecuting Authority is dominant leaders. They prosecute all criminal acts that's committed within the boundaries of South Africa. And the mere fact that they've never decided not to prosecute on this matter, it means that you cannot pursue the route of private prosecution. Private prosecution will only be available to the Meyiwa family if the National Prosecuting Authority issued a certificate of nolle prosecution to say that the evidence there does not warrant them or give them enough so that they can actually put a case, a prima facie case before the court. So now where we at is like, this case needs to be finalized, and if the state don't call any further witnesses, they have to close their case in the defense. Either have to ask for 174 discharge in terms of the Criminal Procedure Act, or they might now call their witnesses to come and say why these accused are not guilty of the crimes they have been charged with. And that's the only remedy. So for now, the Meyiwa family must now wait and see what's happening in this case. And based on that, they can most probably lodge a complaint with the director if it doesn't go in their favor to say, okay, this is the case. But if these 5 accused are found not guilty eventually, then it means that the state can never prosecute unless the state appeals. But for the Meyiwa family, the remedies at their disposal has just become like zero to non-existent, because there's no private prosecution for them on the table to say that they can, unless some other individuals is also charged for the murder of Senzo Meyiwa. And maybe the prosecution then decides we're not going to prosecute them. Maybe they can try private prosecution in maybe docket 375 that we also heard existed, but it's somehow kept in the back room for I don't know what the reason.
Interesting, Alton. I mean, the slow pace of justice also in this case has cast a huge shadow of doubt on how our judiciary actually handles critical investigations that often lead to some perpetrators actually going free due to the technicalities of the case. Now, there are many other such cases. If anything, what should this case have taught us and still be teaching us about the process of justice?
For me, the case should have taught us that you need to have police officers that has a passion for their work, that really wants to make sure justice prevails, and not because certain individuals is involved that a case is investigated in a certain way. They must have made sure that the moment they heard that there was a crime that took place at Vosloorus, that they made sure that the venue is secured, there is no tampering, nobody can enter the crime scene. Then they would have made sure that they cannot get to the crime scene at all. So for me, that was one of the first things that they had to do at the crime scene. Then from there onwards now, how they dealt with investigating people of interest, looking at people of interest in the case, and make sure that everybody of interest is actually sort of considered a person to be questioned of having possible information that was associated with the crime that led to the death of Senzo Meyiwa. Once they've done that, then we would have seen maybe where they investigated all avenues and not have 2 investigating teams coming up with 2 different narratives looking at evidence. Then we wouldn't have had the issue of docket 363 and docket 375 that says these people that has been arrested in the one docket cannot be held responsible, and maybe they should look at different aspects. This is what the case should have told us, that investigators should not try and protect people, but rather to make sure justice prevails and that people, the ordinary men on the street, sees justice is happening in our courts.
And one surely wonders, does the state indeed have concrete proof against the 5 men that are currently sitting in the dock for this murder? Elton, thank you so much as always for your comprehensive analysis. Legal analyst there, Elton Hart, on the 10 years since the death of Senzo Meyiwa, as well as the legal processes that have unfolded.